Hello, I'm Floyd Stokes, your instructor for AJ3, Introduction to Corrections at College of the Redwoods. These series of PowerPoint videos are meant to give you an overview of each chapter of the text, but you will still need to thoroughly read each chapter. Today I want to discuss Chapter 11 of our text, which is titled Legal Issues in Corrections. This chapter has 5 learning objectives. 1. Outline the development and sources of prisoners' rights. 2. Describe types of inmate lawsuits using access to courts and issues of religion as examples. 3. Describe how inmate litigation is limited. 4. Summarize the issues associated with the loss of civil rights. And 5. Explain procedures by which civil rights can be restored. All right, let's get started. Rather than taking an extreme position of constitutional rights being totally lost or all retained upon entering prison, the courts have tried to determine what rights can be compatible with the goals of prison administration. When making that determination, courts turn to a variety of sources, including state constitutions and laws passed by federal and state legislators, but prisoners' rights are primarily found in the U.S. Constitution, including the Bill of Rights, and in the Civil Rights Act of 1964. Remember what we have discussed in previous chapters. Our country was founded as a direct response to what early colonists saw as British abuses of individual rights, and our commitment to individual rights has always been strong, including that persons suspected of a crime are presumed innocent, cannot be detained long without a hearing, are not forced to incriminate themselves, and have protection against unreasonable searches and seizures. Let's take a look at some of the key terms listed in this chapter. Rights are related. This is one of the 2 extreme positions on prisoners' rights. It argues that prisoners keep all the rights of an ordinary citizen except those that are expressly or by necessity taken away from them by law. Rights are lost. This is the second extreme position. It argues that prisoners are wholly without rights except those expressly conferred by law or necessity. Writ of Habeas Corpus. This is a judicial mandate to a prison official, still in use today, ordering that an inmate be brought to the court in order to determine the legality of the prisoner's detention. Ex post facto law. This is a law imposing a greater punishment for a crime than was allowed when the crime was committed. This is prohibited by the Constitution. Incorporation. This is legal theory arguing that all provisions of the Bill of Rights are made applicable to the states through the Due Process Clause. Due Process Clause. That section of the 14th Amendment requiring all states to abide by the Bill of Rights when depriving a person of life, liberty, or property. Equal Protection Clause. That section of the 14th Amendment prohibiting any state from denying equal protection of the law to persons within its jurisdiction. Section 1983 claim. This is a claim brought under the authority of U.S. Code Title 42, Section 1983, that civil rights have been violated, and it comes from the Civil Rights Act. Prisoners have used this federal law as a basis for claims ranging from religion, inadequate health care, staff brutality, to inmate-on-inmate assaults. So what is the basis for inmates' legal rights? 3 constitutional amendments are discussed on pages 184 and 185. The 8th Amendment prohibits cruel and unusual punishment. The question is, does that include not supplying a prisoner with toilet paper, a toothbrush, and toothpaste? Is it cruel and unusual to serve an inmate only 1 meal a day? The 13th Amendment was passed in 1865 after the Civil War to correct continued violations of individual rights because in some states slavery and involuntary servitude still took place. The 14th Amendment, with its due process and equal protection clauses, was ratified in 1868 to make the Bill of Rights applicable to the states. Prior to the passage of the 14th Amendment, the Bill of Rights served primarily to define the relationship between the citizens and the federal government. The text at the top of pages 184, 185, and 186 lists important prisoners' rights court cases starting in 1871 with the Virginia Supreme Court case Ruffin v. Commonwealth, which ruled that prisoners are a, quote, slave of the state, unquote. And cases, for example, the 2011 U.S. Supreme Court case Brown v. Plata, which ruled that conditions in California's overcrowded prisons amounted to cruel and unusual punishment. And you know what happened as a result of that decision. Be sure to review these cases, especially the 1987 U.S. Supreme Court case Turner v. Safley, which is considered by some to be the most important case on prison law because it sets the legal standard for judging whether prison regulations infringe on prisoners' rights. It says that prison regulations are valid as long as they are reasonably related to legitimate penological interests. A legitimate penological interest is the standard used by courts to determine whether a prison policy was developed in an arbitrary manner or out of concern for prison order and security. Prisoners have claimed violations of many types of constitutional rights linked to such things as conditions of their confinement, lack of attention to medical needs, violation of privacy rights, and others. Of the types of lawsuits filed, one related to prisoner access to courts is particularly important because without that access, prisoners would not be able to have a hearing on any of their other claims. In the 1941 U.S. Supreme Court case Ex parte Hull, the court rules that prison authorities cannot restrict an inmate's right to apply to a federal court for a writ of habeas corpus. In the 1977 case Bound v. Smith, the court ruled that prisons must provide adequate law libraries or adequate legal assistance from persons trained in law. In the 1996 case, Lewis v. Casey, the court ruled that the Bounds decision did not create a freestanding right to a law library or even legal assistance. For a violation of Bounds to occur, prisoners must show the provided prison library or legal assistance program is hindering their efforts to pursue a legal claim. Another important type of inmate lawsuit is when prisoners claim violation of the ability to practice their religion. There are two clauses in the First Amendment that deal with this issue. However, free exercise presents greater problems in prison environment. There is a difference between freedom to believe and freedom to act. In the 1940 case Cantwell v. Connecticut, it was determined that the First Amendment gives all people absolute right to whatever religious beliefs they wish, but not necessarily to every action they want to carry out their beliefs, and their conduct becomes subject to regulation for the protection of society. Simply stated, legitimate penological interests overrule any actions for practicing of religion. These are the factors to be considered when deciding if a prison regulation that interferes with the prisoner's constitutional rights is a valid policy. Does the regulation have a valid rational connection to a legitimate government interest? Do inmates have available alternative means to exercise the asserted right? How would accommodation of the right affect correctional officers, inmates, and prison resources? And are there ready alternatives to the regulation? The text discusses judicial involvement in prison administration on page 187. Essentially, courts have responded differently over the years to these and other inmate claims as they moved from an early hands-off approach that essentially let prison officials make decisions without interference from the courts to a period when the courts were very much involved in deciding how prisons should operate, to a current position wherein the courts are more likely to defer to the reasonable assessment of prison officials as to what rights may require violation. The text discusses in detail the Civil Rights Act, prisoner rights, access to the courts, issues of religion, and Turner v. Safley standards on part of page 187 through part of page 190. In an attempt to limit what was becoming a very large number of inmate lawsuits, Congress passed the Prison Litigation Reform Act, known as PLRA, in 1995. That act was intended to reduce the volume of prisoner litigation and improve the merit of those claims that are filed. Indications are that the act has succeeded at both. Three important Prison Litigation Reform Act provisions are explained at the top of page 190. The frequent filer provision, the three strikes provision, and the exhausted remedies provision. A criminal conviction, usually a felony but sometimes a misdemeanor, can result in the loss of certain rights that are typically associated with full citizenship. Depending on the jurisdiction, these lost civil rights might include the ability to vote, serve on a jury, receive welfare benefits, or engage in certain occupations. Because these sanctions are less obvious than actual sentences an offender receives, they have been called invisible punishments, and they are important because of the collateral consequences they add to a sentence. Examples of those invisible punishments and their collateral consequences would be something like sex offender registration, and notification laws, and the disenfranchisement of felons. The text provides an in-depth discussion of civil disabilities and other post-conviction sanctions on pages 190 through 197, but here are some key terms. Civil death. Convicted offenders forfeit all rights and privileges of citizenship, including things such as the right to enter into a contract or the right to sue. Civil disabilities. Convicted offenders suffer a partial rather than an absolute loss of civil rights because of a criminal conviction. Invisible punishments. Sanctions operating mostly beyond public view, yet having very serious adverse consequences for the individuals affected. Collateral consequences. These are secondary consequences beyond the actual sentence that was imposed. Sex offender registration laws. These laws require persons convicted of sex offenses to register in a community even after they have completed their sentence for that conviction. Public notification laws. These laws require the public to be notified of the name and location of certain sex offenders in the community. Residence restriction laws. These laws require sex offenders to live in certain areas or restrict them from living in other areas. Civil disenfranchisement. This is the loss of the right to vote, due, for example, to a felony conviction. Regarding collateral consequences, let's look at those discussed on pages 192 through 194 that would follow a sex offense conviction. Sex offender registration laws, public notification laws, and residence restriction laws. So here's a couple of questions for you to ponder. Should all sex offenders be treated the same, with restrictions after they have served their prison or probation terms? How does this affect treatment and reintegration into society? How do Romeo and Juliet laws factor in the picture of sex offenders? Civil disenfranchisement, the loss of the right to vote, is discussed in detail on pages 194 and 195, and state-by-state felon voting laws are shown on table 11.4 on pages 196 and 197. Do you agree or disagree with California's view on disenfranchisement, or for that matter, disenfranchisement in general? The final topic covered in this chapter is the procedures involved in restoring civil rights. Although every U.S. jurisdiction has a legal mechanism by which at least some civil rights can be restored after a felony conviction, including automatic restoration, these methods vary across the country. The most popular means are through an executive pardon, an expungement or sealing of records, or placing limits on the extent to which criminal records can be used when making employment or licensing decisions. In addition to these common methods, an increasingly popular technique is to issue some version of a certificate of rehabilitation. This issue is discussed on page 198. All right, to summarize this chapter, Prisoners' rights are primarily found in the U.S. Constitution, including the Bill of Rights and the Civil Rights Act. The courts, when weighing rights, have tried to also be compatible with prison administration goals. Access to the courts is important for hearings on any other claims a prisoner may have, including religious freedoms. The courts have gone from a hands-off involvement in many of the administrative directives to now deferring to the reasonable assessment of prison officials. The Prison Reform Litigation Act, or PRLA, as it is known, limits the number of inmates' lawsuits as well as improves the merit of suits that are filed. Convictions of criminal offenses can result in the loss or restriction of civil rights. A person who has lost or had civil rights restricted can regain them through a variety of methods. Before I close, be sure to read page 199 of the text that discusses the case Proof of Rehabilitation. Well, that's it for now. We'll see you in class.